Make sure to give my dad a 5-star review.
Make sure to like and subscribe to his YouTube. Thank you for listening and enjoy the show.
Race, color, religion, sex, and national origin. And so these protections exist. There's also protections under the First Amendment for religious organizations, religious autonomy type protections, protection called the ministerial exception, which allows religious organizations to hire certain key individuals that are furthering its mission. And this is based on this idea that the federal government shouldn't come in and tell a religious organization, no, you need to have this other person promoting your mission and promoting your religious values, right? And so it's really this idea that this isn't the government's role to step in.
Hey, welcome back, Faithful Politics listeners and watchers. If you're watching us on our YouTube channel, we are so glad to have you. And we're also very glad to have you if you're listening to us. You podcast listeners, I got to tell you, you guys are some troopers because our numbers on audio podcasts seems to eclipse our video podcast, and we love you for it. So thank you. Well, I'm your political host, Will Wright. I'm joined by your faithful host, Pastor Josh Bertram. How's it going, Josh?
Doing just fine. Thanks, Will.
And joining us again for the second time is Rachel Morrison. She is a fellow at the Ethics and Public Policy Center, where she focuses on issues at the intersection of law, religious liberty, and public policy. And today we'll be talking with her about a recent EPPC report, Eradicating Anti-Christian Bias, a response to Executive Order 14202, and hear from her, a little bit more about anti-Christian bias in America, Biden's sort of role in it, but then more specifically, 3 things that they outlined in their report that she will unpack for us today to kind of give us a little bit more clarity on actual Christian bias in this country. So welcome back to the show, Rachel.
Thanks for having me. It's great to be here.
Yeah. And, I want to do just a little bit of level setting for our audience. If this is the first time you have heard about a anti-Christian bias task force or anything like that, can you just sort of set the stage for us? Early on in Trump's presidency this year, he established, I believe, a couple different commissions. There was a religious liberty commission, an anti-Christian bias task force, and then a report, the Eradicating I'm gonna screw it up. There was another report that came out. So can you just walk us through what are these commissions? Why was it created? And how does the report that the EPPC developed kind of tie into all of that?
So the Religious Liberty Commission is separate from this anti-Christian bias that we're going to talk about today. And so that's a commission made up of different religious leaders, and they've been holding listening sessions from folks on various topics to hear about their thoughts on religious liberty. And the president of EPPC, Ryan Anderson, is actually one of the members on the commission, which is very exciting. But what our report and what we're going to focus on today is the President Trump's executive order from February 6th on eradicating anti-Christian bias. And so this executive order created a task force to look into anti-Christian bias and directed the task force to issue a report. There was a preliminary report issued within the 120 days with some essentially bullet points from various agencies on what they thought was anti-Christian bias. But the task force itself is gathering input from the public and various religious leaders and different folks to hear about their thoughts on this topic. And then there's going to be a more robust report issued at some point in the future. And so what we did at EPPC is we had seen some of this anti-Christian bias through our work the last 4 years in the Biden administration. And so to maybe just set the stage of the type of work we do. So I direct our Administrative State Accountability Project. And so we focus on federal agency regulations and executive actions. And our mission's to advocate for the authentic understanding of the human person in the drafting, implementation, and rollback of various federal agency regulations. And so we focus on the regulatory actions that affect religious liberty, right to life, non-discrimination, healthcare rights of conscience, those types of issues. And so what we were able to see and observe is that there was this just kind of a disregard for religious liberty more generally Obviously, the executive order was focused on anti-Christian bias, but our report itself is more broadly anti-religious liberty focused that we saw from the Biden administration. And this impacted Christians, I think, most directly with the administration's policy priorities related to abortion and LGBTQ rights. And so their regulations and priority policies there created these tensions with religious liberty or with conscience rights. It affected a lot of Christians, though not exclusively. And so our reports focus mostly on those types of issues and those kind of broader religious liberty conflicts.
Yeah, and I really appreciate your work, by the way. It is so important to have really excellent and high quality, rigorous organizations that are doing this work. I mean, the work is rigorous, right? That's what I mean, that are doing this kind of rigorous work. And I appreciate that. And thinking about Executive Order 14202, is that correct? Is that the... Yes. Okay. The anti-Christian bias.
Oh, wait, sorry. 14202.
14202. 14202.
Yes.
Okay. Good. I'm like, I don't want to misquote that. All right. So it's the weaponization of government. So I would love for you to go in a little bit more depth and even, taking out what you found in the report. But what's the chain of events that convinced you that this was not just rhetoric, but that this was actually more like this wasn't an appeal to, say, a voter base, which seems to be a lot of what maybe those who would lean left or maybe even more center might think it's sometimes like center left on what the purpose of this is. What are the chain of events that are showing that like there are key regulations, court decisions, internal agency moves, things that would show like, hey, this is for real. There is an anti-Christian bias. And is it beyond anti-Christian? Is there anti-Muslim? Is there I guess of Mahmoud, I'm forgetting, but that Supreme Court decision that was about like these parents there was a Muslim group, a Jewish group, and a Christian group that came together. So you see that kind of go ahead, Will, what were you going to say?
Well, I was going to say that was Mahmoud v. Taylor.
Yes, Mahmoud v. Taylor. Thank you. Yes. And so anyway, what have you found essentially that convinced you this isn't just rhetoric on the part of the Trump administration?
Thanks, Josh. So what I like to tell people is we read hundreds of pages in the Federal Register, so they don't have to. And so we've been looking at dozens of regulations, proposed rules, and then final rules coming out of the Biden administration. And so these regulations have the force and effect of law. They bind the public. It affects the services the federal government provides. So this affects federal employees that are working for the federal government. It affects the organizations that partner with the federal government to provide aid or services and the like. So this is a lot of faith-based organizations. And it's also regulations on employers or businesses or the medical profession. And so this is really a lot of regulations affecting every aspect of public and private life. And so what we saw in a bunch of the regulations coming out of the Biden administration, especially those that were related to their policy priorities related to abortion and gender ideology, is that there was just, I think, a disregard for the conflicts these pose for a lot of people of faith. And so there was just a disregard for the religious liberty rights in these various aspects, especially when it came to those policy priorities. And I think this affected a lot of Christians that hold views on life and don't want to participate on abortion, or hold views related to marriage, gender, sexuality that were in tension with what the Biden administration was advocating for. But it wasn't exclusively Christians, right? So this would also apply to Jewish folks or Muslim folks or other folks that have similar beliefs on those policies. And then, so our report addressed three key areas. One was the disregard of conscience rights in healthcare. And so conscience rights in the healthcare space, there's over 24 federal provisions of law that protect these conscience rights to ensure that folks in the healthcare profession don't have to participate in abortion or sterilization or other medical activities that would violate their conscience. And this is broader than just Christian beliefs or religious beliefs. It also applies to moral conviction. The second category was just, I think, a blanket disregard for religious liberty in the rulemaking process, not considering it, whether it was intentional or inadvertent. It just wasn't a big emphasis or something that was taken as seriously as we thought was required because of the legal protections for religious liberty rights. And then the third aspect was actions from the Equal Employment Opportunity Commission to try to minimize religious liberty rights. And I was at the Equal Employment Opportunity Commission, or the EEOC, for a little bit under the first Trump administration and a little bit into the Biden administration, until President Biden fired my boss, the general counsel, which was his right to do. But that seemed to be in response to the general counsel's emphasis and focus on religious non-discrimination and accommodation. And at least that's how we interpreted the firing in the middle of her 4-year statutory term.
Oh, I'm curious about Biden's a Catholic, right? And by all accounts, he goes to church all the time, which, I suppose going to church isn't necessarily a good indicator of how Catholic you are or how Christian you are, but still, he's a Catholic. And
I think it's a decent indicator, Will. I mean, just to push back on, if you look at empirical sociological studies.
Sure. Yeah.
It's for sure, attendance is corresponded with.
Yeah. It's definitely one element when you're sort of gauging religiosity for sure. But on the surface, okay, we'll just say that he is a practicing Catholic Christian, what have you. And mind you, I'm no defender of Biden. I read Jake Tapper's book about Biden, and I want to burn the whole thing down. So with that being said, how do you reconcile kind of Biden's role or responsibility for a lot of these anti-Christian bias, allegations that are being sort of alleged about him? So is it should we think of it as if Biden directed people to intentionally go after people of faith? Or do we view it as he has an administration that are going to do what they're going to do, and, he may or may not have any sort of oversight of it? And I think you alluded a little bit to it just a second ago about your role at EEOC and your boss getting fired. So I'd love for you to kind of help us better understand Biden's sort of role in this whole thing.
Yeah, I think couple thoughts. Biden claimed to be a Catholic. Some of what he seemed to promote seemed to be in conflict with Catholic doctrine. Folks can decide whatever they want. I think I'm not going to opine on, his how religious he is or not. But what we did see was that he issued executive orders that were promoting abortion and were promoting this redefining sex discrimination laws to include sexual orientation and gender identity, which is where a lot of these conflicts with religious rights came into existence. And so these orders that Biden issued directed the agencies to issue regulations. And it's these regulations themselves that posed a lot of these conflicts, or at least what we looked at. And so whatever Biden's personal beliefs on these issues were, or, his faith, whatever, the actions of his administration had this effect. And it wasn't necessarily go target the Christians. We don't like the Christians. It wasn't overt discrimination kind of or emphasis in that effect, but the effect of these policy priorities without respecting the religious liberty and conscience rights protections that are in federal law. That's what we saw. And so it had the effect of having this targeting towards Christians or those who had these certain beliefs on those topics. And so, but though obviously not exclusively. So it's one step removed or a couple steps removed from kind of overt discrimination of Christians need not apply by name. And so, but it was the effect of it itself. And whether Biden realized that or appreciated that, I don't know. But the effect of what his administration did under the policies that he directed his administration to follow is what we see.
Got it. And I want to actually get into your report here and talk about sort of the three things that you all highlighted. But how did you guys sort of land on those three. I mean, in the last report they put out, the 120-day report, I mean, it was like 40 some odd pages of bullet points, in-depth explanations about stuff. When I read the EPPC report, I was looking to see if any of those things that you addressed in your report were also in the task force's report, and I didn't see like a one-to-one correlation. So I'm curious on how did you all land on the three things that you dug deep into?
We were thinking about the work we did and what we had observed, and they fell essentially neatly into these three categories. And so we had started drafting this, and we had we had these three buckets before the initial report from the task force. So what we did had nothing to do with what was not in response to the initial report at all. It was just in response to the executive order and this general idea of what they're looking for. I think there was a few items that were overlap, but our report obviously was much more detailed than the initial task force report that was essentially kind of top line bullet points from the various agencies.
So when you're talking about like concrete on the ground consequences when it comes to this, right? Because that's kind of what we look for in law. And again, correct me if I'm wrong. I'm certainly not a trained lawyer in any way. So, right, please, I'm an amateur, but it's like we're looking for some kind of concrete issue. Like, I guess, like when they get denied certiorari, is that certiorari? I'm always going to say
certiorari.
Yes, certiorari. Thank you. Is that grounding?
We call it cert for short. That's an appeal to the Supreme Court. That's when you ask the Supreme Court to take your case. You file a writ of certiorari, and then the Supreme Court can say yes or no. They say no most of the time, but that's separate from, I think, the executive branch actions in the federal agencies.
Okay, so then it isn't necessarily the same rules applied, which is good to know. And so when we're thinking about the concrete, and I guess my whole point in that, just to be clear, was that when we think about law, we typically think about some concrete effect that it's having on someone that gives them standing. And when we're thinking about like there's a dismantling of the Conscience and Religious Freedom Division. And I would love for you to kind of explain that, what that meant under Biden. And can you walk us through like some specific scenarios, like maybe one or two, where you saw the concrete costs, real world costs of these policies?
So there are over 24 provisions of federal law that protect these healthcare rights of conscience. And so the Biden administration, when they came in and Secretary Becerra for the Department of Health and Human Services, or HHS, we saw a lot of actions that just really disregarded these conscience rights. They eliminated references to religious freedom and conscience from the budget, almost all the references to it. They eliminated the Conscience and Religious Freedom Division, which focused on these rights and enforcing those rights. And the career staff that were part of this division were then reallocated to work on different issues in HHS. There was conscience regulations that the Biden administration issued. They said that these regulations were needed for clarity, but they deleted definitions of the different conscience protections. They got rid of enforcement mechanisms that were in existing regulations to enforce these regulations. And so it was just kind of a minimizing of this robust protection that was currently in the regulations to enforce these conscience rights. And then when you look at like what did the Biden administration do over 4 years to enforce these conscience rights, I think it would be like these violations occur. During the Trump administration, there had been a case involving a nurse at the University of Medical Center of Vermont. And this nurse had been forced to participate in an abortion against her known religious objection. And so there was an investigation under the Trump administration by HHS, and eventually a lawsuit brought by the Department of Justice. When the Biden administration came in, they just dismissed this lawsuit. There was no settlement, no agreement, no compensation for the nurse who had her rights violated. It just went away. And so it just seemed very gratuitous. Like there was no need, right? There was a violation of rights, but the Biden administration decided to take a very narrow view, I think an incorrect view of some of these conscience protections, or just not really emphasizing the priority of enforcement of these conscience protections. There was zero actions that they advertised to enforce these conscience rights. There were some guidances, but the guidances themselves seemed to focus mostly on the rights of individuals who had performed abortion, not to be discriminated against. And so it was very abortion focused, but like pro-abortion focused, and not protecting the rights of those who have objections to participate in abortion, which is really unfortunate. But one of the big problems with a lot of these laws is that there's no private right of action. So a private right of action is essentially a fancy lawyer way of saying an individual cannot go to federal court and sue over a violation of the rights themselves. They have to go to the Department of Health and Human Services, and it's up to HHS to enforce these rights. And because HHS is the only one who is in the position to enforce these rights, then it's really up to the administration or the political party or the folks in the agency themselves to vindicate these rights of the individual when there have been violations. And so there seems to be kind of this ping pong, depending on whether an administration prioritizes this or not, whether these rights are actually protected in practice, even though on paper these rights still exist and individuals have these rights. And so it was just really unfortunate that we can't robustly enforce these rights that exist in federal law that Congress has given, that Congress has recognized as super important. We also saw disregard for these rights in some of the regulations that the Department of Health and Human Services issued. In one of their regulations, they would require doctors to perform sex-rejecting procedures, including on children, under this gender identity non-discrimination framework. It would require institutions to provide insurance coverage for those procedures. And they said explicitly, like, it doesn't matter whether you have a religious or a conscience objection, you would still have to do it. The only reason you might not be able to is if there's some kind of economic or maybe business or like kind of medical consideration that this isn't appropriate in this one specific case. But if you have a blanket objection across the board that these procedures are not good and something that shouldn't happen, that doesn't count. And so these conscience rights are really important in situations where medical professionals are being forced to participate in abortion or being forced to perform a mastectomy on a girl who identifies as a boy, if they also perform mastectomies on cancer patients. And so it's really unfortunate that this was something that was not seen as worthy of protection under the Biden administration. We've seen indications from the Trump administration. I think then Acting Secretary Dorothy Fink issued a statement saying, essentially, we care about religious liberty rights. We're open for business. You're welcome to file complaints if there have been violations of these rights.
Do we know why, like, the Biden administration would remove these provisions? I mean, because we all know that every president that comes in will keep the stuff that they like and, get rid of the stuff they don't like. Like, I think Biden kept some of Trump's original tariffs on stuff. So, like, do you have any indication that what they were doing had some sort of ultimate purpose or goal, or do we just not know?
I think it was essentially, it just wasn't a priority or wasn't something that was seen as being on the same level as other civil rights that are protected in federal law in the laws that Congress has passed. And I think there was this tension between trying to promote abortion and promote these gender identity, non-discrimination protections and the way they viewed that, with having individuals who objected to those things. And so they thought that if they protected religious liberty or conscience rights, I think that it would undermine kind of their policy priorities in promoting those other things.
Yeah, that definitely makes sense. I want to think a little bit about the regulatory processes and thinking like the case-by-case standards, right, that you criticize. And like the idea that these case-by-case accommodation language that I guess was in the Affordable Care Act, that they're not neutral. And I would love for you, essentially, effectively, it shifts power to officials that could be, hostile to religious claims, any number of things, right, that you might see, that bias that could come into that. Can you explain that in more depth? What is the case-by-case accommodation language? Why isn't it effective or neutral? And then maybe like what should it be replaced with? What are you guys suggesting?
So reading dozens of regulations, we started to see patterns in these regulations. And at the beginning of the Biden administration, there was just zero references to religion, just a complete, like, it just wasn't part of the calculus when they were proposing rules. But I think maybe through losing in court when there was litigation over some of these rules or other considerations, they recognized that, like, okay, we actually need to maybe like recognize that there are these rights. And so towards the end, in a bunch of rules, there was this boilerplate paragraph that essentially said, there are rights under federal law for, religious liberty and conscience. Of course, our rule doesn't violate these rights. And so one of these laws is the Federal Religious Freedom Restoration Act. And so this law says that the government shall not. So this is an affirmative obligation on the government. The government shall not substantially burden religious exercise unless like the regulation or whatever it is that's burdening the religious exercise, the regulation or rule achieves a compelling government interest, and it does so by the least restrictive means. So essentially that there's no other way for the government to go to achieve this compelling government interest. And so there's some discussion in some of the Supreme Court cases and case law that, these are fact-specific inquiries, and you need to look at the specific case. And so then what happened is they said that, we'll have to evaluate all of these exemptions or accommodations or these burdens on a fact-by-fact, case-specific inquiry in order to determine whether there's a conflict or whether you have protection. And so this seems like you're just following what the Supreme Court said in this case law. But in practice, this means that individuals don't actually have any guarantee that they have rights or protections. And what we've seen in other situations, so there was a bunch of litigation over HHS's contraception mandate. And the Hobby Lobby case, the Supreme Court said under the Religious Freedom Restoration Act, HHS, you lose because there's other means that you can provide contraception than trying to force religious organizations or religious folks who have objection to these contraception to provide it for their employees. And so you lose because you failed this least restrictive means. And so they also said that essentially if the government can provide it in another way, then the government's going to lose under RFRA. So this is true for a lot of cases, right? You don't need a fact-by-fact, case-by-case analysis to know that if the government's trying to say that, you need to accommodate, you need to pay for an abortion, or you need to provide this medical procedure. There's a lot of ways the government could do that apart from trying to force an individual who has a religious or conscience objection. And so we don't need to have a case-by-case fact-specific analysis in those instances to know that the government would lose. And so trying to push analysis to just an individualized, particularized determination when we already know at the outset that the government's going to lose on this least restrictive means because they have other means to provide these services, it essentially means that individuals, they don't have a guarantee of their protection in practice. They have to go through this onerous process. And there's easy ways to go about it. The administration could still try to require these things and respect religious liberty. There's been examples where there's been forms that individuals fill out that say hey, we have this religious objection. And then the government knows that that they're exempt from the requirement. But the case-by-case fact-specific determination that seemed to be grounded in the law, but in practice it meant that there was no protection or known protection or guarantee of protection, which ended up hurting people of faith. They'd have to go through an entire process to figure out whether they could or could not do something. And so we just didn't think that was necessary and something that wasn't actually required under law in a lot of these cases, because there's all these other ways that the government could achieve their assuming there's a compelling government interest in whatever it is they're trying to achieve, besides trying to go through and force these individuals to participate or do things that violate their religious faith.
So the second element in your report says that the Biden administration's failure to respect religious liberty in the rulemaking process, and we were already kind of talking a little bit about it, but I'd love for you to maybe just expand on that. Number one, like, what is the rulemaking process? You know, and unless I got it messed up, like once a rule or law makes it to, I don't know, the Federal Register or whatever, isn't there like an open comment like period as well where people can, you know, provide their 2 cents, I guess? And then like, does that have any bearing on, you know, the discrimination or the bias against Christians or that what I mean is like if people can submit comments or make recommendations through the comment period, like is that a remedy?
Yes. Well, I'm very impressed about how much you know about the rulemaking process. I think we talked about this last time. So,
well,
he's one of those weirdos.
I should say the job I do to pay the bills, I work a lot in safety. So if you want to know a thing or two about 29 CFR 1926 or 1910, yeah, I'm your guy. I love
it. Yeah, so you're right. So the rulemaking process is essentially these regulations or rules used, you know, somewhat interchangeably from the federal agencies. And so Congress will pass a law, and then the law will direct the agencies to issue more specific regulations. And as I had mentioned, that these have the force and effect of law, and they bind the public. So there's a process before you get to these rules are the law, and you have to comply with them. And so a proposed rule is generally published in the Federal Register, and there's a public comment period where individuals can provide feedback on the proposal. And this could be support, opposition, suggestions for improvement, questions for clarity, you name it, anything or everything. It can be as little or as much as you want. And so through this process, individuals are able to raise religious liberty concerns. And this is something that we did in a lot of our comments on the proposed rules under the Biden administration, and other groups as well that we work with did as well, religious organizations, medical groups, policy groups, et cetera. And so a lot of these concerns were raised during the rulemaking process. So an agency has an obligation to consider the comments. They need to respond to the comments. They don't have to agree with it, right? It's not a vote of, if you have, 51 comments that say you need to keep this and 49 that say no, then you have to keep it. That's not how it works, right? It has to be reasoned decision-making. So something where they take these concerns and then they respond however they're going to respond. And then they issue a final rule. But if they don't respond in a reasoned way, or if they ignore concerns and say, like, there's not any religious liberty concerns, even though all these groups raised these concerns during the rulemaking process, then this is something that can be brought up in litigation and help, like, an argument to invalidate the rule in litigation. And so what we saw was, for example, the EEOC's Pregnant Workers Fairness Act regulation. And so this rule, so the law itself provided pregnancy accommodations for women in the workplace, which was great. But the EEOC issued regulations that said also you have to provide accommodations for abortion, which posed a lot of religious liberty conflicts. And so these concerns and these conflicts for religious employers were brought up in the rulemaking context, and essentially were just kind of disregarded and dismissed by the EEOC in its final rule. They said, like, well, there's these protections in law, but, like, again, this kind of like case by case, fact specific analysis, but, like, we don't know how they apply. And so what's an religious employer supposed to do if someone needs an accommodation for abortion? Like, do they have protections to not provide it if they have a religious objection? Do they not? Do we just have to wait to see whether the EEOC brings an enforcement action at the end of the day, or if the employee, sues because the employer didn't provide that abortion accommodation? Like, how is this going to play out in court? And so just kind of like a disregard for, like, the real conflicts and, like, kind of moral crisis that these religious organizations are going to have as a result of the rule. And so this was brought up in litigation challenging the rule. And there was a successful, like, challenge based on the Religious Freedom Restoration Act, and then also on other grounds, kind of like non-religious liberty-based laws, as well as some kind of other defects with the rule itself. And so this is a way where the religious liberty concerns were important because they were raised and then they were disregarded And so in kind of the response played a key role in the litigation. I'd say on the positive side, we also saw how when I think there was a rule for unaccompanied children that would require facilitation by the Office of Refugee Resettlement for abortion. So this could pose a lot of conflicts for federal employees that have a religious objection to abortion, right? And so there's these federal laws that protect these federal employees who have this religious objection. And so we were able to raise concerns in the proposed rule. We pointed to litigation that was done against the Department of Veterans Affairs abortion benefits rule, where there had been no protections for the federal employees that would have to accommodate the abortion or facilitate or perform the abortions. And then there was litigation and then guidance that was issued that provided these protections. So we were able to point to that as an example. And then in the final rule, there were these protections that were recognized. And so there are positive ways where you can help try to provide these protections, like through the process by raising the concerns. I wouldn't assume that all these federal employees that are drafting these regulations are experts in religious liberty law, that they're experts in your specific religious beliefs or how things might conflict, because individuals that are being regulated are in the best position to know how that regulation is going to affect them, like in the real world, whether it's an employee or an employer, your business, your community. And so this is really important for individuals to be able to speak into that process, to provide that information. Hopefully this information is considered by the federal regulators and the agencies. And we did see some positive responses to those concerns that were raised from time to time, or important concessions that were made by the administration that these laws themselves don't actually contain balancing considerations, right? It's a protection without consideration of kind of all these other interests for some of the healthcare conscience rights. And so So there have been positive impacts. Now, you're not going to, I think, change the policy priorities of an administration, like on the wholesale. Tell the Biden administration, we don't think it's great. You're promoting abortion. You should stop. Like that was, that'd be an unrealistic, I think, expectation. But ensuring that the recognition for the rights, or trying to advocate for that, we did see some positive changes in some limited circumstances through participation in the rulemaking process.
I mean, I think one thing that you said is so key and worth remembering, that it's the person being affected by the regulation that is the best judge of how it's affecting them, not the person writing, these rules. And so I wanted to point that out. There's just a couple things. One, I would love for you to help us understand EEOC, what it is. I mean, just like, I'm thinking part of what I do is I'm kind of like the political, like I'm ignorant, not really, but, but I don't, there's a lot of things I don't know, right? So EEOC would be helpful, I think, for our listeners to know what that is. But more importantly, you're arguing that it has shown disdain. That's what you've essentially said, this part of the argument this whole time, which I appreciate, that it's showing disdain for religious liberty. You point to things like, I guess, removal of a listening session report, failure to update guidance after specific cases that have come before the Supreme Court. And I guess I'm asking this question about the disdain, because so many people might look and think, well, one, there's probably two kinds of people listening. One is essentially saying, I don't see any religious persecution or religious bias or anti-Christian bias, like this is made up. Another part is that essentially would be like, well, the entire mechanism of the left, all of its operating system is designed to essentially erase Christians from influence and from, just go to the extremes, right? How do you answer that question when it comes to, again, like some of the concrete issues that Christians are facing? And if they're employed by the government, I guess I'm trying to anticipate the criticisms that people will bring to this if they're thinking like this is made up or you haven't gone far enough. Where's the balance in this? I hope I'm making sense in the question. Do I need to phrase it, or do you feel like you get it?
Do you want me to talk about this maybe in the context of EOC?
Yes, that would be great. I mean,
Okay,
kind of the, like, I'm thinking dress codes, I'm thinking pronoun policies, things that people have highlighted and kind of help us understand why that's a problem and how this is hoping to fix it.
So the EOC, I guess, maybe to take a step back for folks who might not be as familiar with the alphabet soup of agencies in DC.
Yes, it's confusing.
The Equal Employment Opportunity Commission. So this is the federal agency tasked with preventing and remedying employment discrimination. And so they enforce a number of laws that prohibit discrimination on the basis of race, sex, religion, national origin, disability, age, genetic information. And so when I was at the EOC, I think this has been other folks' experience too, so Congress has protected, a variety of different bases from discrimination in employment, religion being one of them. But religion just seemed to be maybe not as high of a priority or just not a focus. And I think this is what resulted in some of the religion guidance just not being updated with key Supreme Court cases on developments in this law for years and years and years and years, right? It just wasn't a priority. It was seen as kind of a second-class right compared to some of these other important non-discrimination protections that the agency enforces. And again, this isn't to disparage like any individual employee or all the employees at the agency itself, but they just seem to be kind of the general tenor of the EOC, at least in my experience. And so then I think there was some more just kind of overt hostility towards religion. So I mentioned I worked for the general counsel at the EEOC, and she cared a lot about religious non-discrimination and accommodation. And she wanted to hear from folks about what their experience had been just in general, the issues they were facing in the workplace, their interactions with EEOC. And so we hosted, I think it was four listening sessions with folks from various backgrounds to come and share their thoughts on these issues. And this was documented and compiled into a public report that was issued by the EOC. It was posted on the website. There was a press release announcing this report. And right before the general counsel got fired, this report disappeared from the website. The press release announcing the report disappeared from the website, right? Like, this is very gratuitous. Like, why would we remove this public report that's documenting folks' varying opinion on religious non-discrimination and accommodation issues and their experiences with the EOC? Ironically, some folks as documented in the report mentioned that they thought that the EOC didn't value religion as much, which seems to kind of play into what the EOC did here. And so there seemed to be some kind of like hostility towards these religious protections that, again, Congress, has said that you can't discriminate based on religion in employment. And then I think there's this kind of manifests in a different way. So there's protections for religious employees against discrimination, and then also religious accommodation rights in the workplace. But there's also protections for a religious organization to be able to make employment decisions based on religion. And this is something Congress put into the text of the law itself, Title VII, which prohibits discrimination based on race, color, religion, sex, and national origin. And so these protections exist. There's also protections under the First Amendment for religious organizations, religious autonomy type protections, protection called the ministerial exception, which allows religious organizations to hire certain key individuals that are furthering its mission. And this is based on this idea that the federal government shouldn't come in and tell a religious organization, no, you need to have this other person promoting your mission and promoting your religious values, right? And so it's really this idea that like this isn't the government's role to step in. And I think some of this tension comes is sometimes religious organizations act in ways that, maybe we don't like, maybe, right? Or maybe they choose people and we don't like the way they choose people. But the question is what do we do about that? Is it the federal government's role to come in and say, no, organization, you have to have someone else advocating for your mission or working for you on this? Or is it just one of those things that, we can hope religious organizations act in an honorable way, but at the end of the day, sometimes they don't. But like, it's not the government's role to come in and try to change that. And that's essentially where our law is, right? Is there's this space for religious organizations to have to have some autonomy over their employment decisions and the way they conduct their businesses when it's done for religious reasons and to further their faith. And so there's these protections in law and these limits on the scope of the anti-discrimination protections. And so what I saw from my experience, and I think what has borne out in some of the litigation, is the EEOC seems to focus on the employee and not really focus on kind of the limits of the scope of those rights when it comes to religious employers and ensuring that they don't cross the boundary of kind of overstepping into the religious employer. So I think one example illustrates this well is, so if there's an employment discrimination lawsuit and an employer raises religious defenses saying, hey, we're protected under Title VII's religious organization exemption, we're protected under the First Amendment, ministerial exception, you name it, right? Like this needs to be dropped because we have these protections in federal law or the Constitution. Sometimes courts will say, no, we don't think you have those protections. And so then the question is, do you have to go through the entire litigation before a religious employer can appeal that decision? Or, right? And so it seems like it would make sense to have a resolution on that at the outset before you go through years of costly litigation for both the employer and the employee who's alleging discrimination, right? The EEOC has filed some briefs saying, no, we don't think that this should be appealable. Like this determination shouldn't be appealable until after we go through all the litigation. This is just very gratuitous and I think wrong, and something that the EEOC, it hurts everyone. It hurts religious employers. And at the end of the day, a lot of these employers, they're not necessarily in a position to fight the federal government or go through litigation, right? The process is the punishment. And if they're concerned about lengthy, costly, time-consuming investigations by the EEOC or litigation, that puts a chilling effect on some of their religious exercise, which in theory should be protected. And maybe if they go through years and years of litigation, they'll be vindicated at the end of the day. But they have to make a decision. Are we going to do that? Or are we just going to try to comply and use our funds and our resources and our time towards furthering our ministry or our faith, right? And so I think this is just kind of an example of how the EEOC has tried to put its thumb on the scale against religious protections and religious organizations in ways that I think is contrary to law and contrary to the right role of what the EEOC should be doing as a government entity.
This is great, and I just two more questions if you've got the time. One, I just want to just ask you a question about EEOC, and then we'll close by you solving world hunger for us and telling us all the solutions you guys have come up with.
I wish.
So but on the EEOC thing, and I'm not sure if it's connected or not, but the COVID vaccine push during COVID. I would probably say if there's one big issue, I've got friends that, lost their jobs because they didn't want to get the COVID vaccine. I mean, my own personal view, I think it's safe. I don't have any issues with it, but I am very empathetic to people that have very strong religious convictions and didn't want to get it. So is the COVID vaccine stuff tied to any of this EEOC stuff? And if so, does it tie in at all to, what was it, 5,000 or 15,000 service members that chose not to, get the shot, claim religious exemptions, and none of them were looked at or approved or something like that. So I'd love for you just kind of talk about COVID vaccines.
Yeah, so just generally under Title VII, employees have religious accommodation rights. So they're entitled to a religious accommodation if it's reasonable and doesn't pose an undue hardship on an employer's business. And so this is where a lot of the COVID vaccine accommodation requests were coming from, was based on this legal protection they have under federal law. But you probably realize this is a very fact-specific determination, right? Is there a reasonable accommodation? Does it pose an undue hardship? And that's really going to depend on the employee, their role, the employer, a lot of different factors. And just kind of by way of context, the EEOC actually has brought a lot of flu vaccination religious accommodation cases, actual litigation cases. Historically, it's been a good chunk of all the religious discrimination cases that they've brought over the years. And so this is an issue that the EEOC has worked on kind of in other contexts that is maybe less politicized. But when it came to COVID, the EEOC, I think, just really missed an opportunity because this was, I think, a massive discrimination, civil rights type issue, and there was a moment. And what we saw, and I talked to a lot of these employees who were really having that religious moral crisis of, I need to feed my family, but I have a religious objection to the COVID vaccine. What do I do? Right. And so, and I think it's really important to not disregard this conflict individuals were facing. Whether you had an objection or not, it's important to recognize that a number of folks did. And this was really serious and something that should be taken seriously. But we saw what I saw in the process is whether there was a reasonable accommodation, whether there was one that didn't pose an undue hardship, maybe not. It really depended on, the employee or the specific. But the process of requesting the accommodation, I saw a lot of discrimination within that process. Employers trying to tell, for example, a Catholic employee, well, the Pope said it's okay to get the vaccine, so you're religious, and you're Catholic, so even though I'm not Catholic, I'm telling you what Catholic beliefs are, and and you have to agree with the Pope, right? And Title VII it's really the individual's religious beliefs, and it doesn't have to necessarily align with other individuals, right? It's what the individual's religious beliefs are, or just kind of assuming pretext. This is an employee who had worked for a decade for your company, was trustworthy, honest, did all these things, and they're saying, hey, I have a religious objection, and just these inquiries into, well, you need to have a pastor tell me why, and I don't really agree with your reasoning. Well, what about this other Bible verse? Well, I did my own research about the connections to aborted fetal tissue in vaccines. And I really don't think, right? And so just a lot of, I think, religious discrimination in the process itself, before you even get to the question of are they entitled to a religious accommodation or not, which is much more fact specific. And so the EEOC issued some guidance, which I thought was helpful, but they didn't do anything when there was these gross violations and discrimination, I think, in the process itself while all of this was going on. They've started to bring some cases now, and under Chair Andrea Lucas, she's recognized that there really was too little too late by the EEOC, and something they're trying to do now. But if the EEOC would have brought a case or been more vocal about this is not the proper way to evaluate this accommodation request, I think that could have put a stop to a lot of discrimination as it was ongoing. And so just really a missed opportunity. And obviously it was a very political issue. But again, I think it was maybe the combination of religious issues. There was a few disability discrimination cases that were brought kind of in the interim, but not the religious accommodation cases. And then also just it being a political issue, maybe hand in glove. So that was really unfortunate. That was your question, I think?
Yeah, it was. Yeah, thank you. So the last bit of time we have left, I want for you to, as succinctly and I don't know, specifically as you can be without going on for 30 minutes. Not that I don't want to hear you for 30 minutes, but I know our listeners are probably expecting the show's an hour and they're timing, they got to pick up their kids, whatever. So on the three things that you all looked at, the Department of Health and Human Services attacks on healthcare rights, Biden administration's failure to respect religious liberty, rulemaking process, and then the EEOC disdain for religious liberty rights. Give us sort of the top line fix that EPPC is recommending for each of those.
Well, I think so we had a lot of different recommendations within our report of different things the agencies could do. This ranged from guidance from the Department of Justice's Office of Legal Counsel, or rescinding regulations or modifying regulations, et cetera. But I think the one thing that would probably have the biggest impact is if the administration encouraged Congress to pass the Conscience Protection Act. And so this law would provide the private right of action for the healthcare conscience protection laws. So it would allow the individuals whose conscience rights have been violated to sue in federal court themselves without having to rely on HHS or kind of the whims of the administration and the priorities of the current administration on these issues. And I think that could go a long way of maybe depoliticizing maybe some of these issues, right? And ensuring that these protections that Congress gave the American people, right, they exist in law, are actually protected in practice. And so I think that's the one thing that would have the biggest, or the most far-reaching impact of all of our recommendations.
That's really awesome. Well, thank you so much, Rachel. I swear, I keep on talking to you. I've got like I sent you, I don't know how many questions, probably way too many, and I think we only touched on maybe like half of them. So we'll have to definitely bring you back if you're up for it.
Yeah.
And so where can people read this report if they actually want to do their own research?
So the report is on our website. It's eppbc.org. Let's see. And if you just search Eradicating Anti-Christian Bias or response to EO 14202, it should pop up. It's also going to be listed on one of the top results currently for my scholar page. If you click on scholars and then click on Rachel Morrison, it should be there too.
Awesome. Yeah, that's really cool. And we will also make sure we put a link to it in the show notes in case you are not good with the internet. So thanks again, Rachel, for everything. This is
thank you so much.
Been really, really informative. And yeah, this answers a lot of questions for me because again, I've been writing about the Anti-Christian Bias Task Force for the past couple months. And it's interesting because as a Christian, I'm thinking to myself, like, do I have a blind spot for discrimination or bias, and I'm just not seeing it because, like I'm a lib, and of course, like, libs don't really even believe in religion. I'm being sarcastic, but so hearing you talk about the effects of our government making it harder for people of faith to live out their faith in a way that is fulfilling is good, and especially the way that you explain things, it's just really, really awesome. So thanks again for everything. And
thank you so much.
Yeah. And to our audience, hey, thank you for stopping by. And as always, make sure you keep your conversations not right or left, but up, and we'll see you next time. Take care. See ya.
Amen. Thank you.
Amen.